Okay, so I hope audio, video, everything is clear. Now the technical difficulty is sorted. So now I welcome you again to this live session of N100 series, and this is our last class in this series. In this series, we have covered the complete polity from mains perspective, keeping 2025 mains exam in our mind. So we have discussed about the current affair topics as well as the static topic which has the high probability of being asked in the 2025 exam. And obviously, from now onwards till 2025 exam, you shall be getting a lot of current affairs. So you will have to do the value addition from the current affairs. Something new might be added, but well, the basic dimensions, all the bases are definitely covered. And the last topic that I am going to take in this class is about comparison of the Indian constitutional scheme with that of other countries. Well, in this topic, if you do the analysis, there have been basically two type of questions. They are asking about similarity and differences with the vis-a-vis three different democracies. As such, in the very first class, when we have seen that Dr. B.R. Ambedkar had said that democracies are already in existence for around 2 centuries now. Well, the three different models of democracy that have been existent is the one that is there in United Kingdom, another in USA, and third in the France. So they are asking to compare the three organs of the government: executive, legislature, judiciary. So three organs with which three of these democracies. And then there are some other aspects like secularism last year was asked. This is something that we have been studying for time and again, the Western secularism and Indian secularism. This is something that we have already covered when we were covering the preamble. Okay, so keeping things in mind that what are those aspects which are yet to be asked, I have designed this lecture. Okay, so the first thing we are going to study is comparison with the scheme which is prevalent in United Kingdom, that is England, and like parliamentary system, etc. We already know uh, how United Kingdom parliamentary system is similar to India's parliamentary system. The first thing that we are going to study is India and UK judicial system. So what's common between India judicial system and UK judicial system? See, when I talk about the commonality, you may answer, please answer, all of those who are online, please answer to this question. What is common between India's and UK judicial system? But before that, till you write answers, I will tell you a few things. One thing which is a global phenomena is judicial activism. Although in India's context, we do a study that judicial activism is coming from judicial review, and since judicial review is not there with the United Kingdom judiciary, we may think that probably they are not engaged in judicial activism, but that's not true. Even the judiciary in England is involved in interpretation of laws. In fact, all the fundamental rights in United Kingdom have been derived by judiciary by liberally interpreting the meaning of rule of law. Okay, so judicial activism is there. Similarly, PIL, this is also a global concern, whether be it in France, be it in United States, be it in United Kingdom, or be it in India. The public interest litigation, social action litigation, like making judiciary accessible. Accessible justice is the global current across the judiciary. Okay, so these are the things, these are the similarities. Definitely you are going to write. Okay, let's see what else is there where the two judiciaries are converging. One is that in both the cases, the highest interpreter of the constitution is judiciary. This is common across the judiciary. This function, whether it is written constitution or unwritten constitution, The interpretation of constitution, interpretation of the law is going to be done by judiciary only. Next is judiciary has to be an independent organization. Independence of judiciary, this is also common. Okay, removal procedure, here also the removal procedure is very difficult. It also involves a special majority in both houses. Rule of law, we also have. In India's case, rule of law is part of right to equality, Article 14. Rule of law, you might have studied that probably we do not have the three different aspects of rule of law which is there, that we will write in the differences part, but similarity is that we have the core of rule of law is there in UK as well as in India. Next is both of us have common law system. Common law system is basically derived from rule of law only, where there is a common law for everyone, whether he is in administration or whether he is a normal citizen, the law is same. Our justice system is based on adversarial system. In the last class I have explained to you adversarial system. Adversarial system is where judiciary divides parties into one for another against. Both the parties give their argument and then the judges give their judgment. Judicial activism, digitization, this is also something which is going to be common. So in case, I mean, if a question is asked about any judicial system across the world, there are few points which are going to be common. Highest interpreter of the constitution, this is going to be there. Okay, independence of judiciary, it is going to be there. Removal procedure can be different, it may not be same for all the judicial system across the world. Okay, but yes, independence they will definitely ensure. This is the nature of function of the judiciary. Okay, then judicial activism, digitization, these are the things, at least these 4 points are going to be there across the different domain. Okay, next is what are the differences. So in United Kingdom, this is something that we have studied, that they do not have a written constitution, they have unwritten constitution. So in unwritten constitution, there is no difference between a normal law made by parliament and a constitution. All the laws made by parliament is part of constitution. So there is a parliamentary sovereignty. We have seen that judicial review is coming from the fact that we have a written constitution. Since the written constitution is there, constitution is supreme. Whereas in case of UK judiciary, parliament is supreme. So in our case, there is a judicial review and also there is a basic structure doctrine. There is no judicial review. Obviously, there is nothing like basic structure either. There parliament can amend constitution the way it wants. Yes, you are right. The provision of writ is also there. Very good addition. You are applying the things that we have studied. One more point you can write. Writ. So the topic that we had studied, the very first topic, the historical underpinning of Indian Constitution, the borrowings in Indian Constitution, you can write points from there. If we have borrowed certain provision from some country, definitely those are the provision which are same. Okay, we have borrowed equality before law, which is as such part of rule of law from UK. Then there is one concept of juries which is there in United Kingdom. It is also there in USA. Okay, so what is juries? Juries are various. It's like that in India's case, what happens that when a matter goes to the court, it is the judges who are sitting over there, sitting on the matter to decide whether a person has committed a crime or not and what should be the sentencing. In their case, what happens that normal people, they are act as a jury, like they might be engaged in various different professions. Someone could be a retired soldier, someone could be a retired teacher, someone could be a retired doctor, or maybe active doctor, active practitioners could also be there, whoever are interested in doing jury service. Okay, the intellectual from various walks of life, they can act as a juries, and there is a system that on any criminal matter, they act in the criminal cases. So on any criminal matter, there is a fact of the matter and there is law of the matter. So juries decide the fact of the case, whereas the judges decide with the legal aspect of the case. Okay. Now, in India, jury system was there originally, but it has been abolished in 1960. Now, both fact as well as law are decided by judges only. We do not have jury system. Jury system also has a very good advantage that it makes people aware of legal system. It creates confidence among the people about the law. They get an opportunity that yes, someone has committed the crime, he should be sentenced or he should not be sentenced. Okay, it also has various, like India is a country where people find loophole in everything. So people used to find the people who are acting as jury. There can be possibility of managing the justice, but judges can overrule the jury. They have this authority as well. There are further nuances involved. Let's not go into that. Now here, individual rights and liberties as per the third provision of rule of law by Avid Dicey, individual and rights and liberties emanates from judicial decisions, whereas constitution is the source of fundamental rights. Judiciary is merely safeguarding it. Here, judiciary is giving right to the fundamental right. Judiciary is creating fundamental right. All the fundamental rights have emanated by liberal interpretation of rule of law by judiciary. Hereas in India, fundamental rights are emanating by from constitution. Judiciary is merely protector of the fundamental right, not the originator. Although in India also, through judicial activism, various fundamental rights have emerged by judiciary. But I mean, since we are writing differences, this is how the differences in the two systems are there. And in case of judicial system, the system for England and Wales is one kind of system. For Scotland, the system is slightly different. In Northern Ireland, the system is further different. So they have different kind of system in different parts of United Kingdom. Whereas there is an integrated judicial system throughout the territory of India. So that's a major difference. Now, their contempt of court is punishable as per law. Here, the higher judiciary can punish for the contempt of court. So, like one thing is common, that contempt of court is there in both the country. Whereas in England, as per the law, all the courts can punish for the contempt of the court. Whereas in India, it is only the higher judiciary that has got the power to punish for the contempt of the court. And one more thing that we have seen in case of judicial appointment, we have seen that in UK, they have judicial appointment commission for appointment of judges, whereas we have collegium system. This is something unique. This is again a difference that you will find everywhere. Nowhere in the world there is a collegium system. But yes, what is there, what name is called, that can vary. Usually, almost all the countries have a commission kind of system, which have representation from executive as well as judiciary. This is the mechanism. In India, it is the collegium system that is doing the appointment of judges. Okay, if you have any doubt, you may ask. In fact, earlier England had a two-tier system, and the House of Lords which is their upper house. House of Lords has various judicial functions. Now, it was the highest court of appeal in United Kingdom. But then in 2009, United Kingdom has created a Supreme Court of United Kingdom. So now from all the courts in United Kingdom, whether they are in England, whether they are in Wales, Scotland or Northern Ireland, the appeal from their appellate court, whichever is their highest court, the appeal lies to Supreme Court of United Kingdom, which was created in 2009. So before 2009, the House of Lords was acting as highest courts of appeal. It has appellate function, judicial function. Obviously, it was not in tune with separation of power. So at that point of time, had we been teaching, we would have explained it further. But now they have brought their judicial system in sync with the global standard. And the global standard is there should be a separation of power. There should be a Supreme Court, which should be the highest court of appeal from all the higher courts. Okay. Like India, BNS, BNNS is there. Yes, in England also they have separate criminal code and civil code. Okay, so that is also common everywhere. But that is more about the kind of law that they have. Yes, yes, yes. They have codified law. It's not that the criminal laws they have not codified. Like it is the Britishers only who codified it for us. So they have codified law for themselves also. They have different name. Next, we shall discuss about the British Parliament, and here also I expect you to give me a lot of answer. Please tell me what are the commonalities. There are so many commonalities that I do not need to teach it. All of you must be very much aware about this. Please tell me what are the things that are similar between Indian legislature. I mean, what we are studying is Indian legislative system and UK legislative system. Since we have borrowed the parliamentary form of government from there, the first and very much thing which is common, I mean, this is the same point that you will write in executive as well as legislature, is that our parliamentary system, like we also have parliamentary form of government, they also have parliamentary forms. Then we have seen that parliamentary privileges are something that we have borrowed from United Kingdom. In fact, parliamentary procedures and conventions are also continuing in India even today. So those are also the things which we have borrowed from them. We have also seen that we have borrowed the bicameralism, like bicameral structure is there, bicameral structure is there. Lower house is directly elected, lower house is directly elected in both the cases. So there are a lot many things which are common. Let's see which are those things that are similar between the two countries. The first thing is that parliamentary, okay. So there they have House of Lords and House of Commons. House of Common, this is C. House of Common is directly elected. It is not directly elected House of Lords. In fact, there are various ways in which one can become the member of House of Lords. Okay, some are appointed, some are even inherited. Some are appointed, inherited, some posts are ex officio. So this is something which is different from India. India's Raj Sabha is mostly indirectly elected chamber, and then it is the, what you say, few nominated members are there. There is nothing called inherited members. This is like House of Lords over there is not a purely democratic chamber per se. There are big lords which are like kind of they inherit their post in House of Lords. There is no such thing in India. Okay. In among these two houses, House of Common is superior. The House of Lords can't amend any law. Like in India's case, the Rajya Sabha and Lok Sabha have equal power. I have taught you that Rajya Sabha is second chamber, not a secondary chamber. Whereas in case of United Kingdom, House of Lords is secondary to House of Common. House of Common is superior. In fact, in case of no laws, House of Lords have any authority to amend it. Okay. And we have seen that House of Lords acted as a highest forum. So, and with respect to parliament, there is also a parliamentary sovereignty. This is the concept which is there. Indian parliament is not sovereign. Why? Because we have written constitution. Okay. Whereas British parliament is supreme, there is a concept of parliamentary sovereignty. What is the impact of parliamentary sovereignty? Parliament can amend any part of constitution. Parliament can make any law. There is no restrictions at all. Nothing of this sort is there. Our parliament cannot make any law. There is no judicial review. Okay. So these are the things which are there in England. Obviously, their counterpart you can write that parliament cannot amend the basic structure. The laws made by parliament are subject to judicial review. They cannot violate any provision of the constitution. Okay. So even parliament can take away fundamental right. In fact, it is so supreme that once upon a time, one of the kings have been executed at the orders of the parliament. There has been such an instance where a king was not abiding by the instructions of the parliament. The king was saying that I am king. So parliament ordered or rather passed a resolution to execute the king of England. Okay, so that is the level of supremacy that is enjoyed by the parliament over there. However, like in the recent time, you can also say that even the England, obviously, like after Brexit again, like during when England was part of European Union, at that point of time, England has also surrendered some of its provisions, some of its powers, sovereignty to the European Parliament. So, the law made by European Parliament used to be having some kind of binding effect on the England. So, England Parliament has to uh, resolve or pass a resolution in favor of those laws. Well, so definitely some compromise were there on sovereignty of the British Parliament. But then again, after Brexit, that clause is also gone. Now again, British Parliament is supreme. Yes, Manoj is right. There is also a provision that we have already studied. Once a speaker, always a speaker. So by convention, once a person is elected as a speaker, he resigns from his political party. The first thing he does is he resigns from his political party. Okay, and after he resigns from his political party, he remains in office till the time he is interested. No one contest against him in the no one contest against him. This is by convention. The opposition parties also do not field any candidate against him in House of Common election. Okay, so the office of a speaker we have borrowed, but the way their office of a speaker works and the way our office of a speaker works is very different. Our speaker is simply another party person, whereas In their case, the speaker is a neutral person. He is acting truly as an umpire. Okay. So you will definitely be able to write a lot many points in case of parliament. Let's move to the next aspect, that is executive, and then similarity is very easy in terms of executive. We have prime minister, we have the cabinet of minister, uh, the council of minister, sorry, we have the cabinet system, and this council of minister is responsible to the parliament. In our case it is Lok Sabha, in their case also it is lower house, that is House of Commons. So a lot many things are very much similar. The ministers are appointed on the recommendation of the parliament, sorry, on the recommendation of the prime minister. So a lot many things are similar, just note it down. They have parliamentary form of government, executive is responsible to legislature. There is the concept of collective responsibility. This is also written as they swim and sink together. Swim and sink together means if prime minister resigns, it automatically leads to dissolution of the complete council of ministers. Okay, so all the council of ministers, they have to talk in the same language. They cannot talk differently. Either you exist or you do not exist altogether. Okay, and that's it also implicitly means that if a minister in the council of minister has any opinion that differs from the opinion of the his colleague, like council of minister, then he must resign. And that is the thing which is applicable in both India and UK. Next is same structure of prime minister, council of minister, cabinet, different head of state and head of the government. Like in India, head of a state is president. In their case, it is king or queen. So this is something that we will write in differences. Okay, but yes, both are different. Head of government is the real executive, head of state is the nominal executive. Prime minister appoints the ministers, political neutrality of head of state. This is also very important. The head of a state, that is in their case king or queen, it is not politically aligned. In India's case also, the president is expected to be politically neutral. In India's case also, president remains neutral. Leave out political neutral, he remains neutral from all the activity. So that's the difference between the both system, Manoj. That amendment is made by ordinary bill passed by parliament, whereas in India's case, amendment is done by constitution amendment. Good, keep contributing. See, whatever we are studying, a lot many of these things we have studied in different topics. That's why we studied this topic at the end. So keep contributing about the differences, etc. Your knowledge would also improve. There would be clarity. The bureaucratic system, I mean, executive will include bureaucracy, is also very much similar. Okay. Parliamentary control over executive, we have like budget is passed, question hour, all those things, parliamentary functioning methodologies, all those things are similar. And here in both the places, executive action is subject to judicial review. Since we are talking about the judiciary, it's not that, see, their parliament is sovereign, but executive is not immune from judicial review. It has to act as per the laws made by parliament. Okay. So, I mean, when we are saying that there is no judicial review, we were talking in context of laws, in context of parliament. As such, in absolute term, there is judicial review with respect to executive action. Let's talk about the differences. Hmm. So, what are the differences? You please tell. In the UK system, India system, differences with respect to executive. So first and foremost thing is that we are republic. or rather we can say we are constitutional republic. Whereas, I mean, republic has to be constitutional republic. UK is a constitutional monarchy. It means that their head of a state is a hereditary office, whereas our head of a state is elected by people. If not people, they are representative. So our head of a state is elected, whereas their head of a state is hereditary. Okay. Next is we have a federal system. They have unitary system. Since we have federal system, we have the office of governor, chief minister, etc., which are non-existent in their country. Okay. And like their head of state, whichever, they have, and especially with respect to governors, they have some, like governor and head of a state, president, they have some amount of discretionary function, whereas their head of a state or monarch is purely symbolic. As per their convention, they are not expected to take any action. They are just expected to enjoy. This is a major difference. Although we talk in India that the office of president is like a rubber stamp. Well, their office is even more symbolic and ceremonial in nature. The next aspect that is there is a fixed office, fixed term Parliament Act. In UK, they have something called fixed term Parliament Act. So this is something that you can use this information in both in terms of parliament as well as in executive. Okay, with this fixed term parliament, usually this was the problem that their democracy was like very, they do not have anything like anti-defection law, etc. So what used to happen that people were very much vocal on various issues. Even the same political party used to have very divided opinion on various topics. Because of this reason, whenever the prime minister used to find that he has something which he feels about very strongly, but the rest of his other people in the same political party, they are not supporting his agenda, the prime minister used to call for the fresh election. So very frequent election was happening in England. To get rid of it, in uh, 2011, this fixed term of Parliament Act was passed. As per this act, it was said that the Parliament will have a fixed term of 5 years. Okay, and any election in between will have only in exceptional circumstances. And what are those exceptional circumstances? The first exceptional circumstances is that a resolution is passed, resolution in lower house is passed with a special majority. A special majority is 2/3 majority. So if lower house passes a resolution with a special majority that a pre-term election is needed, then only election can be conducted before 5 years. Or the next time is, case is that a no confidence motion is passed. and no government could be formed within 40 days. So whoever was m- making the government, against that government a no confidence motion is passed, but no new prime minister could stake claim or could get the confidence of the house. In that case, obviously, fresh election has to be conducted. Okay, so under only these two circumstances, a fresh election can be conducted. Otherwise, there is a fixed term of parliament that is there. As compared to this, Indian prime minister, here opposite to this you have to write, Indian prime minister can recommend dissolution of Lok Sabha any point of time, at any time. So whenever Indian Prime Minister is enjoying confidence in the House, he can recommend for dissolution of the House. So today, if Prime Minister Narendra Modi want a fresh election to be conducted, he can recommend to the President that please dissolve the House, and President would be obliged to do so. Whereas in England, Prime Minister can no more recommend for dissolution of the House. It is only the House itself which can pass the resolution for dissolution of the House. Or if House passes a no confidence motion in the government and no new government could be formed within 14 days. So that power of parliament to dissolve the House has been taken away in United Kingdom, whereas our Prime Minister still enjoys that power. Okay. Yeah, there also like head of a state do enjoys this power of appointing, but again those are also ceremonial. So in similarity you can say that in terms of ceremonial functions, various appointment are ceremoniously done by the their head of state, and in India's case also our head of state does so, but again in both the cases the real power is with Prime Minister. Is it clear this last point, fixed term of Parliament Act? If you have any doubt, this is one point which is something unique. Your competitor may not write this point, so this is something that you must write in both legislature as well as the executive. And all of you who are watching it online, please like the video. Please share it with your friends, family members, everyone that you come across that yes, there is a playlist where all the classes for all the topics on polity from mains perspective are available. This is something which students find it very difficult because they mostly study from prelims perspective in the beginning and the mains preparation is often lacking. So please like the video and share it. Let's move to the next topic, which is very hot topic. Incidentally, today United States is going to elect its next president. Okay, can you tell me how is election in United States conducted? Yes, Manoj has mentioned another point, which is like difference between India and UK. That UK has dual citizenship. UK allows its citizen to get the citizenship of some other country. Okay, whereas Indian constitution does not allow for dual citizenship. Either you are ours or you are theirs. You cannot be have dual allegiance. Okay, let's understand about the US presidential similarity. Let's first understand, and then in detail I will also talk about the US presidential election, because this is something which is happening today. So there are very high chances the year in which presidential election happen. We have already discussed about how Indian president is elected, the methodology detailed, uh, how, what is the formula to calculate the value of the votes. All these things have been discussed in that executive chapter. Please do refer to that in case you have any doubt. First statement that I am making, many of you might not be aware. I am talking of the similarities, that both these presidents are indirectly elected. You might have studied at various places that president in USA is directly elected by the people, but I am telling you they are indirectly elected. I will tell you how. Okay, do not leave this video here. I will tell you how or why I am saying that they are indirectly elected. Next is that there are political parties involved in the election. So president is a, what you say, uh, usually the political party, the election of the president is conducted on political lines, whether in USA or in India. Although after election, India's president is expected to be politically neutral, whereas obviously US president is the actual head of the state. So he is not expected to be politically neutral. He will be a political person. Okay. And then in the elections, the a state have their influence in proportion of their population. Same is true in India, same is true in United States. Okay. Then in case there is any dispute with the election of the US president, the original jurisdiction is with their Supreme Court. In India also, the original jurisdiction is with the Supreme Court. In USA also, the original jurisdiction is with Supreme Court. Okay. In India, the matter hardly goes to the Supreme Court, whereas in United States, it often goes to the Supreme Court. George W. Bush, when he has become the president for the first time in United States, there was a bitter battle in the Supreme Court. I will tell you about that as well. Then there is a fixed term for presidency. In India also the term is fixed, 5 years in case of president. In US the term is different, but it is fixed, that is of 4 years. Okay, and in both the cases they are the head of the state, US president as well as India's president. Okay, before moving further, I will tell you how US presidential election is conducted. Okay, since today we are having election in United States, it's important that we give some time in understanding how US presidential election is conducted. So United States, they are divided into 50 states. Each state sends two senators. So a total of 100 senators are there in Senate. They also have a lower house, that is House of Representative. There are certain members which goes from this lower house as well. Okay. So the number of electors in presidential election is the summation of the members in House of Representative and the total senators. Okay. So number of electors is sum of House of Representative, members of House of Representative plus member of Senate, which we are calling as senators. So these are the people which eventually is equal to 538. These are the people, maybe I may be wrong about this number, it may be 548 as well. Okay, it doesn't matter much, you have to understand the concept. These are the people who are going to elect the president. But you might be listening into the news that it is the Kamala Harris and Donald Trump who are contesting the election, and then people are going to vote today. But I am here telling you that these are the electors which are going to vote today. So the system is such that, like, let's take the example, suppose New York is a state and there are House of Representative, say 25 House of Representative are there from the New York, and there is two from every state, there is two senators only. So there are going to be 27 electors who are going to be elected from New York. So both these political parties like Democrat and Republican, they will contest election in New York. Okay, and then they have a system called winners take it all. This is again a very controversial system, but US people have it. As per this system, whoever gets more vote in New York, all 27 representatives from New York would be from that political party. So suppose there were say 15 million voters were there. So 7.49 million people voted for Democrat and 7.51 million people voted for Republican. In that case, Republican has got more vote in this state. So all the 27 representative winners take it all. All the 27 representative from New York would be from Republican Party. Okay. So this is how the election would be conducted in every state. So from every state, like both Republican and Democrat, they will have their 27 electors. If Republican wins, all 27 electors of Republican will be declared winner. And these electors, whoever are winning from different state, they are pledged to vote in favor of a particular presidential candidate. Like you already know that since you are a Republican person, if these electors will win, they are going to vote for Donald Trump. If these are the Democrat, if Democrat wins, all these 27 are going to be from Democrat party and they are going to vote for Kamala Harris. Okay, so in this way, we know that actually people who are this 15 million people who are going to vote, they know that actually, although they might be pressing button in the name of these electors, but they know in advance that practically they are voting for these two people, the presidential candidate. Okay, so similarly, the election is conducted throughout the United States. All these 538 people are elected, and then these 538 people vote to decide both president and vice president. So, electoral college for president is same as electoral college of vice president in USA. So, um, the party to which the president will belong, the same political party, the vice president will also belong. The electoral college. Whereas in India, the electoral college for president and vice president is different. In case of president, the MLAs also vote. Whereas in case of vice president, the MLAs do not vote. In US presidential election, the MPs and MLAs have no role to play. These electors, they are not going to be the member of House of Representatives. This is also a common confusion. Although the number is same, the number of electors are going to be the number of senators and House representative, but this is not a election for House of Representative and senators. A separate election is conducted for House of Representative. This is election specifically for choosing president. There is another concept that, well, ultimately out of this 538, either of the two presidential candidates, they have to get the majority, right? Whereas it is a possibility that overall, sometimes it do happen that among electors, someone can get majority. But at the same time, in terms of overall vote polled, the same person may not get majority. That is called popular vote. This dichotomy do appear at some point of time, like it has happened with Donald Trump also when he was elected last time, that he might not get the popular vote. Suppose the state where this Republican people are winning, in that state the margin is less, whereas where they are losing by the huge margin. But it doesn't matter whether you win by one vote or two vote, you will get all the seats. So because of this winners take it all system, it is a possibility that the person who is elected as president might have got the vote of majority of electors, but might not have got the majority of overall vote polled in the country. So in that case, the popular vote, he may not enjoy majority in terms of popular vote. Okay, any doubt in terms of US presidential election, you may ask. Unlike India, where we have various political parties, we have coalition system, they do not have coalition system. They have simple two major political, although theoretically they also have multi-party democracy. But practically for these 3 centuries, this is how like their democracy has evolved. In within say 1 decade, we have led to formation of various political parties. Whereas in their system, there are 2 political parties only. See what happens that uh, how election is conducted. So, to elect the president, an electoral college has to be set up. Okay, and this electoral college will have members. These members, every state is assigned a particular number. That from New York, 25 people will come. From California, 20 people will come. From say some other state, these many people will come. Okay, we know a few states, we do not know all the states. Okay, so how many people will come from which state is decided based on this formula, that how many people are there in House of Representative, it's like how many people are there in Lok Sabha and how many people are there in Rajya Sabha. In their case, in Rajya Sabha, every state has 2 representatives. But like in every state, like in UP, in Bihar, we have different number of MPs in Lok Sabha. So is the case in in USA also. They also have in House of Representative the number of representative in proportion to the population, right? So different states have different number of MPs or member of representative in House of Representative. So accordingly, the number of electors are decided based on this formula, that how many members are there in total. Okay, I have taken an example of New York, where 25 members are there in House of Representative and 2 members are there from senators. So a total of 27 electors would be sent by this state of New York. Similarly, some state of say Washington and California, Florida, it will send different. No, Florida probably sends uh, 30 electors. Okay, so 28 are, I mean, how 30 is coming? Based on number of representative in House of Representative, 28 plus 2 in Senate, total 30. So 30 would be sent by Florida. Now what is happening, that accordingly various states, some states, even a smaller state, send 3 member as well. Okay, one for the House of Representative, 2 for the Senate. So all the state have sent these members, then these members will vote to elect the president. But these members are already, they are not, they are selected on state wise, unlike in India, where like even if 27 members are elected to be elected in India, like in Indian election, what happens, that we divide a particular state, say Telangana, in 27 different constituency. In USA, they do not do it like that. They do not divide the state into constituencies. There is no concept of constituency with respect to presidential election. The whole state is acting as a constituency. So overall, whole state is voting whether it has to vote for Democrat or Republican. And if Republican wins, all the 27 seats from that particular state goes to Republican, because of this system called winners take it all. Okay, so accordingly, different state, all the state conducts election and they decide whether they are going to vote for Democrat or their state is going to vote for Republican. And after that, finally, they are going to. So in India, the system is same, that MPs are going to choose the Prime Minister. But in our case, the MPs are elected by a particular constituency. In their case, MPs are elected by a state. So a state decides that whether our MPs are going to be Democrat or Republican. And how many MPs are going to be from particular state is decided by this formula, that how many members are there in House of Representative plus how many senators are there from your particular state. Is it now clear, Manoj? Well, there are certain other differences as well. Hmm. In USA, the candidate is selected through primary elections. So within a political party, there are primary election. If you win the primary election, then you are nominated as a candidate. In India, there is simple system of nomination. You have to file the nomination. You have to just gather the support of a minimum required number of MPs or MLAs, and you can contest the election. Okay, so that's why their election exercise starts almost 1 year ago. In our case, it usually starts 1 to 2 months ago. And like the campaigning etc. is much more extensive here, much less extensive here. Like even campaigning, in case of our presidential election, the campaigning is very minimal because the electoral college is not the, I mean, not the whole people are not involved, whereas there in election, the whole people are involved. Here the president gets 2 terms. In India, there is no limit. neither in president nor on prime minister. There is no limit on the number of terms one can be president or prime minister. Okay. In case of succession, suppose like president resigns or president dies in his office, the vice president act as president for remainder of time. For remainder of term. Whereas in India, he acts as president only temporarily. He does not remain in the office of president for the remainder of term. Okay. And there is also difference in terms of removal procedure. In terms of removal, the process of removal in USA starts in House of Representative, and House of Representative only have to pass a resolution for simple majority, and this they are calling it as impeachment. So if House of Representative passes a resolution with simple majority, the president would stand impeached. Donald Trump was impeached twice in his one tenure. And in the history of United States, there has only been 3 instances of a president being impeached. Sorry, 4 instances. Out of 4, 2 instances have been with Donald Trump. There has been 3 presidents who have been impeached. However, although they are simply calling this as impeached when a resolution was passed with simple majority in House of Representative. Okay, the impeachment does not mean removal. Okay, after this, the matter goes to Senate, and Senate passes it with a special majority. Senate act as like a jury where a proper investigation is done. So Senate act like a court. All senators act like juries. They listen to the matter, and then Senate passes with a special majority. Then president is removed. So both houses have different role to play in the process of impeachment. In India's case, a special majority is required in both houses. The matter can be initiated in either house. No president has been impeached in India. Clear? Any doubt? Next, we are going to see the veto power of president. How veto power of US president is different and similar from the veto power of Indian president. Do you remember? Just mention it in case you remember. What is the article in which the veto power of Indian president is discussed? Let's see if you remember it or not. Let's move ahead. If you remember, please mention. You can mention in the comment section if you are uh, watching it in recorded format. The first thing is that both are written in constitution. Second is that both of them have suspensive veto. Suspensive veto is that they can send it for reconsideration of the house. Although in USA there is something called qualified veto, which is different from India's suspensive veto. Very good, Manoj. You remember article number 111. Then legislature has got the power to override the veto. There is also a concept of pocket veto in both USA and India. But the way USA's pocket veto function is very much different from India's pocket veto. In case of India's pocket veto, the pocket veto has come from the fact that there is no mention of time period within which the president has to give assent. Whereas in USA, the pocket veto functions because the time period is mentioned, but with some conditionality. So the president in USA has to exercise veto within 10 days. There is a mentioning of time period except excluding Sundays. So although our prime minister do not take holiday on Sunday, on any day, whereas USA president is allowed to take holiday on Sunday, it seems from this article. Okay, so he has to exercise it within 10 days. What if he does not decide within 10 days? Then there are two possibilities. See, one thing could be that Congress is still, I mean, after 10 days, within 10 days, the president did not decide whether he wants to give veto, he wants to give assent or want to exercise veto. Then there is two possibilities that Congress is still in session or Congress is not in session. Congress is prorogued. In case Congress is still in session, the bill will become a law. And in case Congress is prorogued, then the bill is dead. So it is called veto power because the president can make a bill or can ensure that a bill is dead. A bill does not become a law even without saying that he is exercising veto. That's why we are calling it, or rather they are calling it as pocket veto. So I will just sum it again. A bill is passed. Within 10 days, president has to decide whether he wants to give assent or not. Now, president has not taken any decision. Then it would be seen that whether on the 10th day the Congress is still in session. If the Congress is still in session, the bill will become law. If the Congress has prorogued itself, in that case, the bill is dead. It is a bit peculiar. I mean, how does it matter whether Congress is in session or not? No logic seems on face of it, but then it is their convention, like in USA, they give it its weightage that the USA Congress can assert its assertiveness or assert its bill on president by not proroguing itself. By not, I mean, they do not use the word prorogue, they simply use the word adjourn only. Okay. So, by not, but the meaning is of proroguing. Adjournment will happen obviously on daily basis. Okay. So, by not adjourning itself, the USA's Congress can make sure that a bill passed by the Congress becomes an act. Okay. The second thing is that no veto power is available in case of constitutional amendment. In India's case also, the constitution writes Article 368 that the president must give his assent in case of a constitution amendment bill, and it is a part of checks and balances. We have studied it that although both the countries have separation of power, at the same time both the countries also have checks and balances. And then veto power is a discretionary power of the president. So unlike the United Kingdom, where uh, the monarch is only doing a symbolic function, there is no discretionary function. Here in both our countries, which are republic in nature, they have discretionary power to the president. and one of the discretionary power is veto power. Now let's discuss about the differences between these two countries. And the differences first is that in case of India, USA. In case of India, we have only suspensive veto, whereas in USA, they have qualified veto. So, in case the president reject a bill, president says that I am applying veto, and then in that case, what will happen? The matter will go again to the Congress, and then in that case, Congress will have to pass it with a special majority. In India's case, the second time also the parliament has to pass it with the same majority, that is simple majority. In USA case, the second time the Congress has to pass the bill with a special majority, then it would be automatically considered passed. In case of Constitution Amendment Act, again President assent is required. President has to give his assent, but president assent is required in Constitution Amendment Act. No assent required. See, USA people, they say that something which is meaningless. A president has to give assent. Why? To send it to the president. Once all the formalities are completed, like their Constitution Amendment requires a special majority in both the houses, and it also requires that 3/4 of the state should ratify. So once this process is completed, then automatically the Constitution Amendment takes into effect. No assent of president is required. Okay. Then there is no, in India there is also absolute veto. In USA there is no concept of absolute veto. In India no time limit is there. In USA, there is a 10 days time limit. Within 10 days, the president has to decide whether he wants to give assent or not. And the major difference is that in India, very rarely used, especially by president. Governors still uses it very frequently, but the presidents have not been using the veto power, whereas it is very frequently used. And in India, when even when it has been used for on constitutional ground. So it is usually, or like when opposition also approaches the president that a bill should not be given granted assent, it is the constitutional ground on which it has been used, whereas it is a political tool in USA. See, in USA there is a separation of power. So the purse is controlled by Congress. Sometimes it does happen that president wants to implement a particular policy to which Congress is not agreeable. In that case, if the law or the bill passed by Congress is not or is vetoed by the president, so both they enter into a compromise that Congress will pass the budget which is required for that policy, and in return the president will give his assent to a particular bill. So it is a very much a political tool in USA, whereas in India it is mostly a constitutional tool, and it is very rarely used, whereas it is very frequently used in United States. Is it clear? If you have any doubt, you must ask. Here we are going to conclude the USA's constitution. Obviously, there are various aspects of constitution. I have taken a few aspects because of the paucity of time. Next, we are going to start the French Constitution. French system is a little bit more complicated than either of these two systems. There also we are going to study first about the French parliamentary form of system. See, in terms of parliamentary system, still there is a lot of similarity because they also have bicameral legislature. Uh, Being a bicameral legislature, they have lower houses, they have upper houses. Lower house is directly elected, upper house is indirectly elected. Uh, but their form of system is very semi-presidential in nature. So there a lot of differences will come, but let's see first what is the similarity. They have bicameralism, lower house is directly elected, bills can be introduced in any house, upper house is indirectly elected in their case also. It approves the budget, it controls the executive, so all those functions which are there. Government is responsible to the lower house, the same thing is there. Okay, here I am using the word government because they are having semi-presidential form of government. In semi-presidential form of government, like there are three type of government. One is parliamentary form of government, another is presidential form of government, and third is semi-presidential. In one case, the prime minister is the real head, real executive. In another case, the president is the real executive. In this case, both are real executive. The president also has some power, whereas prime minister also has some power. There is division of power between prime minister and president. Okay, this is the French system. Okay, they call it their they call their lower house as National Assembly. Pakistan also calls it as National Assembly, and their upper house as Senate. Not this lower house. Senate is their upper house. In the lower house, they also use first past the post system, the constituency and all those things, the way we have in India. In upper house, they also use the proportional representation in the election. There is an indirect election in upper house. Proportional representation system is used. Then they also have the mechanism of judicial review. So their parliament is also not sovereign, or their legislature is also not sovereign. But where are the differences? The differences, first let's just understand about the differences in structure. So like they had two houses. The lower house is completely similar to India. The lower house is directly elected. It is based on the constituency, first past the post system. There is a prime minister which remains responsible to the lower house. But the upper house is very much different. In their upper house, which is called Senate, what happens that there are representatives from municipalities, there are representatives from provinces, which are called region over there, and then there are departmental representative as well. Okay, so it also have multiple representatives, but not only from the regions or provinces. They have region, they have municipalities, they have departments. Do not write provinces because they are using the word regions. We will also use the word regions, which are giving representation. There is no nominated member in their Senate. All the members are indirectly elected, no nominated member. Anyway, the nomination of members in the upper house, from where have you borrowed? Have you borrowed it from France? Obviously not, because France doesn't have this system. So we could not have. From where have you borrowed? Please give me the answer. Okay. Second point is that from Ireland, we had borrowed it from Ireland. Second is that their Senate is also secondary chamber. It can also not reject a or can't reject a bill. Okay, so there also, yes, Ireland, you are right, Manoj. So they cannot also not reject a bill. It is also a secondary chamber. So like the question is also asked that USA's Senate is the most powerful Senate, because yes, actual removal power of president is also there with the USA's Senate. In there you have just seen that House of Representative is just, I mean, passing it with simple majority. So real power there lies with Senate, whereas in case of French Parliament or UK Parliament, their lower house is more powerful. In India, both the houses are equally powerful. Okay. Next thing is about the Constitution Amendment. Okay. There, the Constitution Amendment Act requires referendum or 3/5 majority in joint session. So once a Constitution Amendment Act has been passed by both the houses, after that there would be either a referendum, it would be decided by the government whether it wants to go for the referendum or it wants to have a joint session in which it has to be passed by 3/5 majority. 3/5 is like 60%. Okay, it is less than 2/3. 2/3 is 66%. Yes, yes, you are right, Manoj. Then their parliament, uh, like this is something that we shall study in judicial system. In our case, what happens that once a law is passed, it becomes an act immediately and come into effect immediately. In France, that's not the system. There is a constitutional court, and that constitutional court reviews the constitutionality of the law before it comes into effect. Okay, so in India, like we have Citizenship Amendment Act, many of you or rather most of us do feel that probably it is unconstitutional. Still, it is in effect, people are getting citizenship. Maybe after say 5 years, 6 years time, the Supreme Court will someday declare it unconstitutional, but it will remain constitutional for that much period of time. It will be implemented for that much period of time. In France, they do, I mean, before implementing the law, they do the review. They call it as prior review. Okay, I will write it in uh, judicial part, when we shall be discussing the differences in judicial system. Okay. There we have also said that in France there is a system of executive law, which we are calling here as ordinance, but ordinance is only in case of emergency that it can be used. So it's an emergency provision, whereas in case of France there is a system of executive law. Executive can make law. Okay, in case executive can make law and that law become valid and remains valid forever. There is no such thing like within 6 weeks of reassembly of the constitution, you have to pass it by reassembly of the uh, houses, you have to get it passed. It's simply if a law is passed by the executive, it become an act. The only condition that is there is that in case it is rejected by the house, It has the effect of no confidence motion. So in case executive law is passed and a resolution is passed by the houses or like the assembly against this law, in that case it would be considered that a no confidence motion has been passed against the government. And then government would again have to, either government have to resign or government would have to pass the confidence motion to win the confidence of the house again. So it is very risky to bring about this executive law. Mostly government does not resort to it because if like there is no anti-defection law over there to safeguard the interest. So in case people opinion goes against a particular law, there are chances that the government will lose majority in the house. Okay, and there it does not happen that if government has brought a law, it would always be passed because the government enjoy majority. The MPs, like this is something that happens in all these three democracies that we are discussing. The MPs take their independent call, they apply their mind. So even their prime minister have to convince their own MPs first whether we should be bringing this law or not. In India, like Modi ji, whatever he says, it will happen. It happens like this, not in those mature democracies. Okay, so it is very risky for the government. That's why government does not always resort, but yes, theoretically, that's why also it is said that the French president is probably the most powerful president of the world. Why? Because it has an overriding power, it has a lot of legislative power also. You see, there is a kind of despotism. It has executive power, it has legislative power. Okay. Then the president can dissolve the house. See, there, why this fact is important, president can dissolve the lower house, which is National Assembly. Because it is the prime minister who is enjoying confidence of the lower house. But then it is the president who can dissolve the lower house, and president is directly elected. President is not a nominal executive who has to act on add on advice of the prime minister. So president is real executive, and that president has got the power to dissolve the lower house, not necessarily on the advice of prime minister. So that's why president has a lot of control over legislature in France, and that's also the reason why it is called that probably French president is one of the most powerful president in the world. And there is a, I have already talked about it, there is a Constitutional Council. In fact, we have already discussed about Constitutional Council once. If you remember, Constitutional Council reviews the constitutionality of a law before it is promulgated. We have discussed about the Court of Secession and Court of rather Cassation and Constitutional Court. The idea of having regional benches of the Supreme Court. We have discussed. So that idea was coming from France, because in France they have this kind of system. There is a constitutional council that deals only with the constitutional matter, and for appellate matter they have Court of Cassation. Okay, so now let's discuss the French judicial system as well. First, let's discuss the similarity between the two. Similarity is like there is independence of judiciary. We can also say that there is a separation of power. This is also something which is effectively true in all the processes. There is hierarchy of courts. There is three-tier hierarchy there also. Here also we have three-tier hierarchy. But and there is also an element of judicial review. There is protection of fundamental right. There is judicial activism. There is PIL and collective action, that is system of legal aid. So these are the things that we have discussed. And like judicial activism is there also leading to enhancement of the scope of judicial review or fundamental right. The meaning of fundamental right is being broadened there also by using judicial activism. But then in the differences part, the differences are more. There is a comment, sir, who are the members of Constitutional Council? Yes, judges, judges. The Constitutional Council is the name. That's it. I mean, by council it gives an meaning that probably they are elected people. No, they are not elected. They are judges only. So they on the constitutionality of any matter, and it is not like the all the laws which are passed by their legislature is referred to that. They have the system that in case the prime minister or leader of opposition or a speaker of the house or more than 50 members of national assembly, if like these people, if they request that probably the constitutionality of the law should be tested, in that case only the constitutional president also. So in case these people, it's not that any Tom, Dick and Harry like a normal citizen will approach the constitutional court and the constitutional court will uh, go and review all the laws. So in case these dignitaries, they have the the MPs etc., they feel that probably the law passed might not be constitutional. In that case, the constitutional council will first do the review of the law. Okay, and after that review, uh, the matter would be declared as constitutional or unconstitutional. See, usually they did not have the concept of uh, reviewing a judicial review of the laws, because they have the concept of this they are calling as priori review. So since they have the concept of priori review, that before a law is promulgated, it would be reviewed by the Constitutional Council, they did not have the concept of judicial review in our sense that someone can later on, maybe 5 year, 10 year down the line, can go and challenge the law in a court. But now they have also included this concept of posteriori review, where a law can again be challenged for unconstitutionality, again in the same constitutional council, for violating the constitution. So this is something that they have introduced as recently as probably 2006 or 8. Yes, 2008. This is something that they have introduced in 2008, and this is not 50, this is 60. 60 members, 60 parliamentarians, they should make a request in that case. But apart from this, there is one more thing that is very much different with respect to both judicial system as well as the legislative system in France and in India, is that they have something called administrative law and administrative court. And if you remember, like if you are a student of public administration or political science, you must have studied it, that the AVDIC has given this concept of rule of law in the context of France. He has said that French have something called administrative law, whereas United Kingdom have rule of law, which is also called as common law system. Okay, so in this system, what is happening, that there is a two different set of law. One is like civil law which is applicable on everyone, common citizen, and there is another set of system, that is administrative law, which is applicable on administration. So suppose you become IS, If you have different set of law for you, then it would be like administrative law. Administrative law not only deals with the like different set of law for those in the administration, it also deals with the laws that regulate the relationship between citizen and administration. Okay. Now the next point is that probably this is not much to be worried about, because see, the relationship between citizens and administration, there are a lot many laws like RTI etc. that has come, which is dealing with the relationship between citizens and administration in India also. The Right to Services Act has also been passed by various state government in India. Okay, so nowadays most of the countries have these kind of administrative law, although they're not telling it as specifically that there is a different set of law, set of code to deal with administration. France has this kind of system that yes, the law should be different for normal people and for those who are in administration, and there should be a set of law that should be dealing with the relationship between administration and citizens. They are calling it as administrative law. Okay, but probably the most striking difference between the two is administrative court. There is a separate set of court also which deals with the matter involving administration. Like if we have a separate Supreme Court to deal with administrative matters. So if I have a dispute, civil dispute or criminal dispute with the normal person, I will go to the different court. If I have the dispute with the government, income tax authorities, etc., I will go to the different court. In India, we have a common law and common court. Now see, the tribunals that we have in India, they are very much similar to their administrative court. Those tribunals, they mostly deals with those matters where like a specific matter related to administration, like scat, this deals with the administrative matter. Income tax appellate tribunal, so these are the tribunals that mostly deal with the matters where government, citizens and government interference is involved. They are like mostly manned by administrative people. Like these administrative court, they also have a specialist from administration. So much similar to the tribunals that we have, but well, our tribunals deals with various other matter. Like we have consumer forum also, where not necessarily the government and citizens are at war with each other. Okay, or at in litigation with each other. So our tribunals are not exactly same as administrative court. So that's why they're different as well as similar. And then we have already told you that they have a highest court of appeal. So like there are two set of court, administrative court and then the common court. So for them there are two different appellate court also. So the highest court of appeal for administrative court, there is a for sorry, there is, let's see, for administrative matter, in case of administrative matter, and then in terms of common law or civil, sorry, they call it as civil court. So in case of administrative matter, in case of civil matter, they have court of appeal, and they have something called council d'etat. Very difficult to remember the name. Council d'etat. I don't know if I am pronouncing it correctly or not. The spelling is correct. So for administrative matter, the highest court of appeal is council d'etat. and this also have the advisory jurisdiction to the president. This is called court of cassation. We have said na, there is court of cassation which is highest court of appeal, appellate court, and this court of cassation and constitutional court, constitutional council, and then since there are two set of laws, for those they have one for court of cassation, for another they have council detached. Okay, so that's all. French system is a bit complicated. UPSC has not been very fond of French system, but definitely one day UPSC will wake up and will ask questions from the French system. So that's all that I have to cover with you about the various aspect of polity. At this stage, we come to conclusion with the polity. Thank you very much for your discipline and dedication that you have shown for attending these classes. In case any doubt has been left, you can write a mail to me also. My email ID is madhusudan@narayanagroup.com, or you can connect with me on my various social media handles. The username for all of them is madhusudan_IIT. From next Monday, so we have the break in this week. From the next Monday, we are going to start the economy classes again. All the content for the complete economy would be covered from the mains perspective only. So the basics of economy, I would request you that in these 4 days of break, you cover the basics of economy, all the aspects like what is current account, fiscal policy matters, deficit, etc. And then it would be fun to have watch the interaction of various topics of economy discuss with you. Okay, so take care, have a nice day, see you again with the next set of topics. Thank you for joining me. क्या वो बंद नहीं हो रहा था क्या?